Good morning, everyone. Welcome to today's hearing. Today we're going to hear further evidence from a member of the London Fire Brigade. Yes, Mr. Kinnear, who's your witness?
So with your permission, may I call David Brown?
Thank you. Good morning, Mr. Brown.
Good morning.
I gather you're going to make the affirmation. So the words are there on the screen if you'd read them out, please.
I do solemnly, sincerely and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth and nothing but the truth.
Thank you very much. Now please sit down and make yourself comfortable. All right?
Yes, thank you.
Thank you very much. Yes, Mr. Kinnear.
Thanks, sir. Good morning. Would you please confirm your name for the record?
David Brown.
Thank you. Mr. Brown, thank you very much for attending to give evidence today. Before we start, just 3 pieces of advice I should give you at the outset. First of all, if any of my questions are unclear or too long, please say so. The fault's mine, and I'll shorten them or clarify them. Secondly, if you could keep your voice up, that's so that the transcriber can capture everything you say and accurately. And thirdly, if at any stage you require a break, please say so, that's not a problem. We will be having a break at about 11:15 in any event, and then breaking for lunch. Now, you have provided 2 statements to this inquiry, is that right?
That's correct.
And the first one is dated the 29th of January 2019, and we can find that at LFB 000-32166. And is that your first statement?
It is.
And if we go to page 25, is that your signature?
It is.
Thank you. The second statement is dated the 16th of December 2019, and that can be found at LFB 000-84020. Is that it?
That's correct.
And again, if we can turn to page 25 in this statement, is that your signature?
It is.
Thank you. Have you had the opportunity to read both those statements recently?
I have.
And can you confirm that the contents of each are true?
They are.
And are you happy to have those statements taken as your evidence to this inquiry?
Yes, I am.
Thank you. And I can take it that you have read and familiarised yourself with the exhibits to both of those statements?
Yes, I have.
Thank you. Now, the first part of your evidence today, I'd like to discuss the roles and responsibilities you held most recently in your time at the London Fire Brigade. First of all, am I right in understanding that you joined the LFB as a firefighter in 1985?
That's correct.
And that over the next 20 years or so you held a number of positions, progressing up the ranks, until in July 2006 you started in the temporary role of Assistant Commissioner.
That's correct.
And initially for service delivery, but later in operational response. Is that right?
That's correct.
In June 2008, you were promoted to the permanent post of Assistant Commissioner for Service Delivery, North East and North West areas and mobilising. Is that right?
That's correct.
Now, if we can go to your first witness statement, LFB 000-32166/3, and paragraph 6, you say here this: my primary responsibilities in the role of AC service delivery, North East and North West areas, and mobilising, were to take a strategic overview of the planning, direction and delivery of LFB's operational service to Londoners in the North East and North West areas, and the mobilising service to the whole of London. In that role, I reported to the Deputy Commissioner, which was Roy Bishop, until October 2009, and then Rita Dexter until the 31st of March 2015. Now, in that particular role, were you responsible for managing all of the LFB's fire stations in the North East and North West areas?
Yes. So London was split into 4 areas: North East, North West, South East, South West. So basically the north of London, broadly defined by the River Thames.
Thank you. And did that role include responsibility for overseeing the planning, direction and delivery of Section 72D visits specifically?
It did, yes.
And the management of operational risk information in the North East and North West areas of London?
In terms of collection and application, yes.
And for those who may not be familiar with those terms, first of all, Section 72D relates to the LFB's duty to obtain information for the purposes of extinguishing fires and protecting life and property in the event of a fire in the area, and visits to premises were the means by which the LFB primarily gathered that information.
That's correct.
And in relation to the phrase management of operational risk, that describes the LFB's procedures and systems to collect, manage and use the information at operational incidents. Is that a fair summary?
And in training, yes.
Thank you. Did your role as AC service delivery and mobilising have a counterpart, namely AC service delivery for the South East and South West areas?
Yes, it did. And in the 4 years I was doing that role, there was 4 separate colleagues that undertook that role at various times.
Was Andy Barrett one of those individuals?
He was, yes.
And was Andy Barrett responsible for managing the LFB's stations south of the river?
Yes.
Although separately responsible for your individual areas, would you and AC Barrett collaborate on London-wide service delivery?
Yes, we had offices next door to each other and we met daily.
And would that collaboration extend to matters relating to Section 72D visits and the management of operational risk information?
Yes.
Now, in October 2010, is it right that you were given the additional role of third officer?
That's correct.
Now, if we can go back to your first witness statement, which is on the screen, in paragraph 8, which is on page 4. Now, here you describe what being the third officer involved, and you say this: my primary responsibility in the role of third officer was to provide brigade-wide operational cover. The Commissioner, the Director of Operational Resilience and Training, and the third officer provided brigade-wide operational cover between them for major or serious incidents, 24 hours a day, 7 days a week. And if we can go back to paragraph 5 at page 3 of this statement, you say in the final 5 or 6 lines of that paragraph this: in June 2012, the role of AC service delivery, North East and North West areas, and mobilising was disbanded, and a single role was formed to consolidate responsibility for all 4 areas of North and South London, mobilising and community safety. Following that restructure, the department was renamed Operations, Prevention and Response, and I was the AC allocated to that department. Now, did that role change mean that you became responsible for managing all of the LFB's fire stations across London from June 2012 onwards?
Yes, effectively the 2 AC roles were combined into a single role.
And so did it follow, therefore, that the role included responsibility for overseeing planning, direction and delivery of Section 72D visits for the whole of London?
Yes.
Now, in April 2015, you started in the new position of Director of Operations, into which your existing role and responsibilities as AC was subsumed. Is that a fair summary?
Sorry, can you just repeat that again?
Yes, of course. In April 2015, you start in the new position of Director of Operations, into which your existing responsibilities were subsumed. Is that a fair summary?
Yes. Because it was a role that involved the amalgamation of 2 assistant commissioner roles, it was accepted from the beginning that it was an extensive role and closer to that of a director. And when Rita Dexter left in 2015, that role was elevated to that of Director of Operations.
And was Miss Dexter's departure the prompting for that particular restructuring?
Yes.
Now, if we can go back to your first statement in paragraph 9 on page 4, you say this, just flowing on from the answer you've given actually: my primary responsibilities in the role of Director of Operations were to take a strategic overview of the planning, direction and delivery of LFB's operational service, the mobilising service and the corporate, regulatory and community safety service to the whole of London. In that role, I reported to the Commissioner, which was Ron Dobson until the 31st of December 2016, and then Danny Cotton until my retirement on the 31st of March 2017. 4 heads of department reported to me: Head of Fire Stations, Dominic Ellis; Head of Fire Safety, Neil Orbell until March 2016, then Dan Daly; Head of Central Operations, Adrian Fenton; and Head of Control and Mobilising, Tom George. Now, in broad terms then, the new Director of Operations role included your previous responsibilities as AC of Operations, Preventions and Response, as well as the additional responsibility for corporate, regulatory and community safety service. Is that a fair summary?
Regulatory fire safety, yes. I already had responsibility for community safety. So community safety and regulatory fire safety were amalgamated into a single department, and we just called it fire safety.
And presumably, given the answers you've given, you remained responsible for managing all of the LFB's fire stations across London?
Yes, although the addition here was there was Assistant Commissioner put into that role specifically to manage fire stations, and then I was in the director position overseeing that.
So ultimately responsible?
Ultimately, yes, but in effect took one step back as a director.
Thank you. And were your responsibilities as third officer also subsumed into your role as Director of Operations?
Yes, if I can just explain briefly, the third officer role was purely an operational role. It wasn't a managerial role of any way, shape or form. It was prompted by the fact that there needed to be three most senior officers at a strategic level. And when Roy Bishop left and Rita Dexter became Deputy Commissioner, there were only two. So it was the Commissioner and the other Director. So they needed a third person to manage the operational rota. And after an interview process, I was successful in that. So I took on the operational responsibility, but it never made any change to the managerial role in any way, shape or form.
But you continued in that position as third officer until your retirement in March 2017?
Yes, because when I became director, there was therefore naturally three positions at that level that were operational, so there was no need for a third officer as such.
Thank you. Now, your statement, your first statement in particular, identifies specific actions relating to 72D visits and operational pre-planning for which you were responsible. Now, as we go through your evidence, we'll discuss those in more detail, but I think it'd probably be helpful to identify those responsibilities now so as to provide context for later questions. Now, if we can stay in your first statement and go to paragraph 14, which is at the bottom of page 5. Now, you say there and over the page that you were jointly responsible for Lachnal House Board Action 21, is that right?
Yes.
Now, the Lachnal House Board actions were actions identified by the Brigade after the Lachnal House fire, but before the inquests, is that right?
Yeah, they were 34 pre-inquest actions that we identified ourselves as a board.
And just for context, the Lachnal House fire was in 2009 and the inquests were held in 2013, is that right?
That's correct.
Now, as we can see, if we turn to page 7 of your statement, and we see there in the last row of the table on page 7 a description of Action 21, and it related, as can be seen, to the level of pre-planning at residential high-rise buildings, and specifically the move to include line drawings showing individual flats that Cruz would prepare as part of 72D visits. Is that a fair summary?
Yes.
Now, if we can go to page 9 of your first witness statement and paragraph 22. Now, there we see another table which shows the action points that were overseen by Elfipa's Lachnal House Working Group, of which you are either the lead or joint lead. Is that right?
Yes, these were actions that we formulated ourselves in order to meet the coroner's recommendations.
We'll come on to that in due course, but just for anyone who isn't familiar with the phrase, Elfipa was the London Fire and Emergency Planning Authority.
Yes.
Now, as you intimated there, sorry, before I interrupted you, these were post-inquest actions, is that right?
That's correct.
Yeah. And they're intended to discharge the recommendations made by the coroner following the inquests?
Yes.
And they include, if we see in the third row, Action 2B, B for Bravo, which was the creation of an inspection regime targeted at high priority buildings. Is that right?
Yes.
And the third work stream for which you were responsible was post-inquest actions. And if we see in the fifth row of this table, Action 2D, D for Delta, which was to set corporate targets for 72D activities. Is that right?
Yes.
Now, if we can go to page 22 in this statement, paragraph 72, you say there, in relation to Action 2B, B for Bravo, this: I was the lead for the introduction of LFB Policy 800, Management of Operational Risk Information. The policy sets out the way in which risk was assessed and inspections prioritised. Now, if we can just go briefly to that policy, which can be found at LFB 000-83849. And if we amplify the top third, we can see that the Policy 800 deals with management of operational risk information. It was first issued in July 2012 and reviewed as current in August 2015. When did you start work as the lead in relation to Policy 800?
So Policy 800, well, first of all, just to add some clarity, it continued. You can see an old instruction number on there. So it was a continuation, an updating of what was an existing policy, and we did this as a result of Lachnal House. I think it originally belonged to one of the operational policy departments, but then after Lachnal House, it became apparent really that it was my staff within fire stations that were ostensibly working towards this. So I then took ownership of the policy around about late 2012, early 2013.
So after its original issue?
Yes.
Now, I hope I'm not oversimplifying matters in this regard, but were you effectively the Brigade's senior point man in relation to 72D visits and the management of operational risk information?
In terms of 72D visits, yes, although there were a variety of other senior officers that were a key part of that. In terms of operational risk information, then collection and application, but the systems that were used to support that were very much within information management, which was in strategy and performance, because they owned the database and they looked after, administered and quality assured the database.
But bearing in mind your responsibilities at this time, bearing in mind that it was your firefighters who were having to implement this, would you accept that you were perhaps the best placed, almost the senior placed person within the LFB in terms of knowledge, experience and position to influence and implement the Brigade's operational risk management strategy?
Certainly it's the case if there were questions about the operational risk strategy, then yes, I will be the person that someone would primarily come to.
Put differently, would the buck land with you?
Again, in terms of collection and application, yes.
Now, can we turn on to the question of Section 72D visits? And if we can go back to your first statement, LFB 000-32166/15 and paragraphs 41 and 42. Now, there you say, under the heading Pre-Planning for Residential High-Rise Fires, you say this: Section 72D of the Fire and Rescue Services Act 2004 places an obligation on LFB to obtain, store and disseminate information for the purpose of firefighting and protecting life and property. The way in which the LFB discharged this duty was by conducting visits to property, 72D visits, and storing the information collected on their operational risk database, the ORD. There was an incentive for firefighters to complete 72D visits and record accurate information, as ultimately it would enhance their safe working practices. Now, apart from complying with the statutory obligation itself, in your view, or indeed the corporate view of the LFB, was there any other purpose served by 72D visits? Familiarisation
with buildings, familiarisation with station grounds, and then there was the ripple effect, because the more familiar station-based staff, i.e. firefighters, would become with the station's ground, the better they would get to know the community. So the inquiry, I'm sure, is aware of the fact that we were massively moving into a prevention-based role. We'd always carried out prevention work, but certainly we was massively up in our game in so much as trying to reach out to the community, reach out to hard to reach people in the community and try to prevent them having fires. Just one quick anecdote, we'd go to public meetings and we'd say to the public, what do you want from the fire service? And they would say to us, well, we want a fire engine now as soon as we call it when there's a fire. And we just say, well, no, it's not really what you want. What you want is not to have a fire engineer at all. So we want to work with you to prevent there being a fire. So we was working really hard to try to prevent fires, which was one of the reasons when I became Director of Operations that we amalgamated community fire safety, which is about prevention, and regulatory fire safety, which is about protection, into one role.
Thank you. Now, if we can turn to Policy 800, and particularly Appendix 1 of Policy 633. Now, first of all, can we go to the revised version of Policy 800, which can be found at LFB 000-83849. And as you see, this is one we looked at earlier. This was the version published in August 2015, has the title Management of Operational Risk Information at the top. Now, Policy 800 governs the LFB's approach to the collection and dissemination of operational risk information which is obtained via 72D visits. Is that a fair summary?
Yes, obtained by 72D visits, but it does also mention there are other ways of obtaining information as well. So, although 72D visits was a key component to obtaining that information.
I think in Section 72D visits you accepted earlier on, they were the principal or primary means by which that information was collected. Is that a fair summary?
Initially, yes, but then ongoing revisits, then we would try to use other strategies as well to make life more efficient in terms of firefighters' time.
We'll come on to other means of collating information in due course, but for obvious reasons I want to concentrate on Section 72D today. Now, I think I'm right in saying that this version of 800 is the version that was in force at the time you retired in March 2017.
Yes, I believe it was. It was a 3-year cycle, so if this was reviewed as current in August 15, then one imagines the next review would have been in August 18, by which time I was retired.
And so would have been the policy in force at the time of the Grenfell fire?
I believe so.
Now, would you agree that Policy 633, which concerned high-rise firefighting, and in particular Appendix 1, were also relevant to information collected as part of Section 72D visits?
Yes.
Now, can we go to Policy 633, which we considered in detail at Phase 1, but it can be found at LFB 0001256. Again, this is the version as at June 2015, so presumably you accept it's the one that was in force at the time of the Grenfell fire and when you retired.
Yes, I believe so.
And this would be subject to the same 3-year cycle as Policy 800,
Yes.
Would that be right? Now, having looked at 633, if we just briefly go back to 800, which is at LFB 000-83849, and if we go to page 2, now you'll see at the very bottom of the page, I expect this is well familiar to you, in Section 3, it sets out 5 stages of really designed for the identification and assessment of risk. And if we just briefly go through those as providing context for the sort of next questions. First of all, stage 1 is the identification of premises that might potentially give rise to hazards and risks. Stage 2 is the initial site analysis, and the guidance asks, does the site require a visit? Stage 3 is information gathering, a detailed examination of the site where risks identified on the premises risk assessment, the PRA sheet, can be verified. And if we go over the page, stage 4, risk assessments, using the information to decide whether the site requires a scheduled station visit, the frequency of the visits, the level of information recorded, whether site-specific training is required, level of information on the tactical plan, and finally stage 5, completing the operational risk database, recording the information. The ORD is linked to the station diary and will be completed, updated for each scheduled station diary visit. Now, having looked at that 5-stage process, is it right that in carrying out the risk assessment at stage 4, Policy 800 requires crews to complete a premises risk assessment, or PRA, using the tick sheet at Appendix 1 of this policy?
Yes, so that premises risk assessment probably would have been completed at stage 3, but stage 4 is consolidating and considering the information in terms of determining frequency of future visits.
Thank you. And if we could turn to Appendix 1, which is on page 13. this is the tick sheet, and everywhere relevant, each box would have to be considered and marked as appropriate by the visiting crew.
That's correct.
Now, is it also right, having regard to the 5-stage process, that Cruz would then calculate the risk score of the premises using the premises risk assessment template, which is on the screen here, and apply that score to the risk matrix?
Yes.
Now, let's look at the risk matrix itself and go back to page 8 and paragraph 10.1. Is that the matrix?
It is, yes.
And in broad terms, the matrix determines whether and how frequently premises should be subject to further scheduled Section 72D visits. Is that right?
It is, yes, and we used it to maintain consistency across the brigade.
Now, just so that we understand the significance of a premises being identified as requiring Section 72D visits, is it right to say that essentially its significance is twofold? First of all, the fact of the visit, and secondly, once premises are identified, and if its risk score is high, or sufficiently high, the premises and relevant details are then recorded on the operational risk database.
That's correct. There was also something called a premises information plate, which I guess we may come on to later, that sat alongside this, but that was almost exclusively for high-rise.
Thank you. Now, is it also right that frequency of visits were determined by the premises risk score?
Yes, and in professional judgment of the station manager.
So 2 stages.
2 stages, yes, yeah.
And we can work this through, but if we can look at the risk matrix itself, and if we could look at the yellow row, which is medium to low risk, we can see that if a premises scored between 250 and 499, that would require a visit at least every 3 years. And then moving the column further to the right, it says, if deemed appropriate by station manager. Now, would that mean that the station manager could make visits more or less frequently depending upon his assessment of the risk presented by a particular high-rise building?
Well, depending on his or her assessment, yes, they could, but the expectation wouldn't be that they would make it less frequent, it would be more frequent.
Thank you.
Can we just check that we haven't misunderstood this? When I looked at this for the first time on the screen, I assumed that the box which says if deemed appropriate by station manager actually relates to the heading on the top, on-site exercise required.
Yes.
So whether visit frequency would always, I suppose, be at the discretion of the station manager, but it would be at least once in every 3 years.
Absolutely. If the station manager, in his or her professional judgment, felt that whilst the matrix had suggested this, there should be a reason why that frequency should be more often, then that's when we would expect them to intervene and change the operational risk database to reflect that.
Yeah, but whether an on-site exercise required at all would be, as the box suggests, up to the view of the station manager.
Yes, although if I can just add one thing, I've seen different versions of this within that document. So this matrix appears twice. I think it appears once within the body of the document, the policy, but it's also in the appendices as well. Mm-hmm. And it'll be useful to see the one in the appendices, because I'm not quite sure whether the visit frequency is different, because in all others I've seen it suggests 1 year and 1 to 2 years, not every 5 years or 3 years.
If we go to page 17, it seems to be the same.
Okay. I've seen other versions where the low was 1 or 2 years and it was asterisked, and it was for the station manager to determine whether it was 1 or 2 years. So I think subsequent iterations and earlier iterations, it was demonstrating a more frequent
Well,
visit
certainly
schedule.
in this version of 800, which was current at the time of the fire, both the matrices, both the one at page 8 and 17, are identical.
Okay.
You can take that from me. Now, If we can go back to page 8. And if we can look at the green row, and it sort of sets out the approach to premises attracting a score of 150 plus. Again, would those premises be added to the ORD and subject to regular visits?
Yes.
And in relation to premises whose score was under 150, paragraph 8.2, which can be found at page 7 of the policy, that could be amplified. That provides, thus, any new premises that scores between 0 and 149 will not be included on the operational risk database. Any existing premises scoring between 0 and 149 should be deleted from the outside duties master schedule. So is the practical effect of that provision this, that if a premises risk score falls below 150, the premises will first be deleted from the ORD, and secondly, they will not be subject to future scheduled visits?
That is the intention, and just to put some context behind this, the operational risk database had taken over from a previous application called the Central Risk Register, and this was before we had more advanced systems that we have now, and even at the time. And so the Central Risk Register, in transferring over, needed to be cleansed. So I guess that's what's referring to when it says should be deleted from the schedule, because in case there was some on there that never really should have been on there. But now we had a much more advanced and technologically supported way of determining what should go on the register. In saying all of that, and staff understood this, station managers have understood that if a premises did come out to between 0 and 149, but the professional judgment was such that that just is an affront to common sense, then that could be included necessarily on the operational risk database.
Was that overriding discretion vested in station managers something that was well understood by those station managers?
I would say so, yes, and certainly by borough commanders.
And that, can you identify when and in what format station managers were told that they ought not to follow the risk matrix robotically, that was always going to be subject to their discretion?
Yes, so I used to host borough commander meetings religiously every quarter, and it was something that had been done even prior to my commencement in service delivery in 2006, and that was a fantastic way of keeping in touch with what was going on within boroughs.
How did you make sure that the borough commanders were telling their station managers not to follow a robotic approach to the risk matrix, but to ensure it was subject to their professional judgment as to the risk presented by a particular building?
Well, firstly, it wasn't just about not following a robotic approach to the risk matrix. It was about having sound judgment and integrity to be able to stand up and say things are wrong or are right whenever they felt that to be the case. So it was far broader than just a matrix. But the way I would determine it is because, in addition to meeting borough commanders on a quarterly basis en masse, then I had a scheduled programme of meeting the area deputy assistant commissioners on a monthly basis on a one-to-one, and that would include me visiting them out in their areas with the relevant borough commander. So, for example, in the northwest area, I'd meet the northwest area deputy assistant commissioner maybe 1 month at Wembley and see the borough commander for Wembley there at the same time, and another month I might meet them at Heston and talk to them there. So I would be able to personally satisfy myself that people understood, and the dialogue that we used to have with borough commanders and station managers was very much in terms of staff would stand up and say things that they didn't agree with.
Thank you. Now, if we can go to page 14 in this policy, in the very bottom of that page, we see that the very last box says this: high-rise premises, e.g. over 6 floors or 18 metres, would attract a score of 75 points. Now, that provision aside, is the process for determining which properties would be recorded on the ORD applied equally to high-rise buildings as to any other building?
Yes.
Put differently, there was no bespoke 72D process particular to high-rise buildings.
No.
Thank you. So is it right that whether a high-rise building received scheduled 72D visits depends upon the nature of the risks that a particular building presents, which in turn determines that building's risk score?
Yes.
Now, during your time at the LFB, would you have expected that all high-rise buildings would have met the threshold of 150 points?
Yes. I think for a high rise not to meet that threshold, it would need a combination of two things. One would be absolutely zero risk whatsoever, and you could go through the various iterations of this matrix and see all the various things that factored into it, such as no elements of hoarding, no one living in the high rise that was non-ambient, no unoccupied premises. So first of all, it would need a near perfect solution, and then also it would need quite possibly some advanced fire suppression systems, because with some aspects of this actually reduce the score rather than add to the score.
So your practical expectation would be that all high-rise residential buildings would be recorded on the operational risk database, is that right?
Invariably, there may well be some that do fit in that category, but I'd say looking at all of them, I'd say the absolute vast majority would be on there. And if they weren't on there, there would need to be very good reason why not.
Put differently, were you ever aware of a high-rise residential building that a decision had been taken not to include it on the operational risk database?
There was no such building ever brought to my attention.
Thank you. Now, can we go back? We touched on Appendix 1 of 633. If we can go back to that, that can be found at LFB quadruple 01256/19. Again, this is a document that was subject to particular scrutiny at Phase 1, and it provided guidance to crews carrying out 72D visits at high-rise premises. And we see at paragraph 1 at the top of the page, the guidance says this: during 72D visits, personnel should ensure they are familiar with the following and their impact on firefighting and search and rescue operations. And then it sets out 22 particular items. Now, in her evidence at Phase 1, the then Commissioner, Danny Cotton, was asked whether, from a practical frontline firefighting perspective, some of the matters in Appendix 1 were impractical. And she agreed that that was the case, and stated the Appendix 1 list needed, and I quote, rewording, close quotes, and that some of the items on the list were, quotes, not realistic, close quotes. And she also stated that frontline firefighters don't have the technical knowledge or ability to be able to do some of those things. Now, during your time as Director of Operations, and also as your time as Third Officer, did you expect crews carrying out Section 2D visits to familiarise themselves with each of the 22 matters set out in paragraph 1 of Appendix 1?
My expectation was that they would use this as an aid memoir, and they would look at these various component parts, and where practicable and possible and realistic, then they would take them into consideration.
Just looking at paragraph 1, the words where realistic or where practicable aren't there, are they?
No, but I think if I can put some context behind this.
Please do.
And I understand this has been an issue in Phase 1, but the word should carries a lot of weight in London Fire Brigade. We had lots of discussion on terminology in terms of should versus must. And where we say should, we use that word carefully and deliberately. And the reason is because we see should as being a word that describes where practicable, whereas must is there's no flexibility, you will do it. And we had lots of, so every policy that gets promulgated to staff has to go through union consultation and sometimes negotiation. we were going through a period for quite some time actually where relations with staff side were not as good as we would have liked, and we had to carefully tread through various terminology, and our legal advice at the time was must means you will and should means you may. And we used to have that understanding with the Fire Brigade Union, and staff at stations, as far as I'm concerned, understood the difference between should and must.
I suppose your evidence is perhaps slightly more subtle than former Commissioner Cotton's. What you're saying is, depending upon the particular building, it may not be realistic or reasonably practicable to do each of the 22 items set out in Appendix 1.
Yes, I think probably it does need rewording, because from the outside looking in, if it needs a level of explanation I've just given, then clearly it could be clearer. I accept that.
Looking at it from a different perspective and based on the evidence that Commissioner Cotton gave, would you agree that frontline crews lack the technical knowledge to look at each and every one of these matters?
Not each and every one. There are some issues within here that sit perfectly and exclusively in terms of frontline crews.
Can we look at it slightly more directly? Look at the 10th bullet point, which is the likelihood and impact of any fire spread beyond the compartment of origin and the potential for multiple rescues. Is that something that falls within the category you've just identified, i.e. that operational crews would be sufficiently able to identify and assess the likelihood and impact of fire spread beyond the compartment of origin?
Fire crews at stations, so station-based staff, didn't have the technical fire safety knowledge to be able to look in depth in terms of breaches of compartmentation and fire safety regulations. So I think unless there was something that was absolutely obvious, so for example, an open vent above an exit door into a common stairwell, then no, I think it's beyond that. It is outside the remit and wit of a firefighter. No disrespect meant to firefighters, they just weren't employed or trained in that level of technical detail.
So the key word in your evidence there is in-depth, and that, if I can summarise it this way, you'd expect the reasonably competent crew to identify obvious matters such as vents, but nothing more than that may have an effect on compartmentation. Yeah,
I've used vents just as an obvious example, which I think any person would realise, but beyond that required any specific training, then no, I wouldn't expect them to be able to do that, and that probably is a good example of where realism rears its head in terms of this list.
And I suppose looking at matters slightly differently, how would you have expected them to have considered the issue of likelihood and impact of fire spread on a 7.2D visit?
Well, when they arrive, the common way of conducting a 7.2D visit on a high-rise will be to do what we call is walk the building. So they would get in a lift, they would go to the top, and then they would walk down and they would check each floor, intermittently looking at common areas. Dependent on the time of day and if applicable, they will be expected to maybe even knock on a door and see if a resident would allow them access, so they could just see what the construction was in terms of the way the compartment was laid out. They will also, if possible, do it with the responsible person, so whoever had oversight of that building, and they then could give them some advice and guidance in terms of some of the questions.
We'll come on to the involvement of the responsible person in due course, but if crews, you wouldn't ordinarily expect crews to be able to assess likelihood and impact of fire spread beyond compartment of origin.
No.
How would London Fire Brigade go about assessing that likelihood in relation to high-rise residential buildings?
So high-rise residential buildings, in terms of fire safety regulation, involve a mixture. So there's the individual compartments which don't come under legislation, but then there's the common parts, i.e. stairwells and escape routes that do. So in terms of looking at that particular issue, then fire safety would have been involved with the original planning and construction advice, etc. And then in terms of regular audits, or even if there had been an incident there, fire, so been a post-fire audit. So fire safety regulation would have an involvement with a building in the same, under the regulatory reform order, in the same way as firefighters at stations would have an involvement with it under 72D.
So let's just look at that. There are two means on the basis of that evidence by which likelihood of spread is examined. First of all, at the time of the original design. Now, presumably, you're indicating there the involvement of fire safety in the building control process.
Yes.
Is that what you're thinking of there?
Yes.
And so, if, for example, that building control process doesn't happen, or fire safety is not involved, that route does not allow the LFB to assess the likelihood of impact of spread, does it?
If that hasn't happened originally, then that is the case. However, in saying that, one would expect, if station-based staff are out and about on stations ground doing a whole variety of jobs that they're doing, a new construction clearly wouldn't bypass them. They would involve themselves in terms of carrying out a 72D. That would be placed on the operational risk database, and fire safety had access to the operational risk database. So eventually it would become within organisational knowledge, although it would be a clear omission on behalf of the construction engineers and the responsible person why they never informed the fire brigade in the first place.
But it assumes a proactiveness on the part of a visiting crew, doesn't it? If they're to pick up that there may well be changes that require more detailed fire safety involvement.
I was picking up on the basis that a building had been constructed originally and never been alerted to the fire service. Not so much about a building that was already in existence and they were inspecting it and talking about some kind of constructional change.
Now, the second means you identified was a fire safety audit related to the RRO. Now, forgive me, it's not entirely clear when and by whom you saw that particular role being fulfilled.
Fire safety audits will be carried out by fire safety inspecting officers, and they would inspect buildings as part of a programmed, proactive campaign, or it might be a reactive visit because of something that's happened. So that could have been a fire there, so we carry out a post-fire audit, or it could be that they've been alerted by the local authority that there's been some kind of construction going on in that building, so they inspect it to see whether it still complies. Or it might be a complaint from a member of the public who might see things happening and say, I'm not happy about this, I live in this building, I'm concerned. Or it could be the borough commander in liaison with the local authority has come to their attention and he or she would alert fire safety.
Thank you. Now, if we can go back to the bullet point list, and if we can look at the 12th bullet point, which reads, floor layouts and any building construction features which may promote rapid or abnormal fire spread, such as sandwich panels, timber frame construction, atria and voids. Again, would that be the type of matter which you wouldn't expect a visiting crew ordinarily to pick up on?
Yes, this will be something that's at the extreme ends of the expectation of the knowledge of a firefighter.
And your assumption, therefore, would be that those issues would be picked up by one or both of the alternative means that we've just been discussing?
Yes.
Now, where the text refers to, or uses words such as sandwich panels, am I right in understanding that that was not intended to be an exhaustive list of construction features? They should just be on the lookout for particular features that may well have an impact on fire spread, evacuation, and the rest of it.
Yeah, that was an example to focus the mind.
Would you expect a crew to be alive to the risk presented by cladding systems, albeit in very high-level terms?
Crews were aware and probably have experienced fires in high-rise where cladding has become involved, so it's within their operational knowledge, skills and experience. In terms of whether they expect cladding to be an issue that would be a predominant part of a fire, and indeed flammable to the degree where it could envelop a building, then no.
Now, just staying with that question of cladding, could we go briefly to GRA 3.2, which can be found at LFB 0001255, and then once we've got there into page 18. There we go, GRA 3.2. And if we go to the second line of the fourth bullet point from the bottom of the first list, and that bullet point starts with the words building construction features. And it provides this: building construction features such as the presence and location of maisonette-style construction, sandwich panels, timber framing, cladding systems, surface-mounted trunking, ducting and voids, in addition to features which present a specific hazard, such as asbestos. Now, can you help us at all as to why cladding systems which are expressly referred to in GRA 3.2 were not specifically referred to in the 12th bullet point of Appendix 1 of 633?
So can I just see the paragraph that sits above these bullet points?
Of course.
Please? And can I read the bullet point again, please?
Of course, yes.
So GRA, Genetic Risk Assessment 3.2, about high-rise, would have been national guidance, and that would have been the responsibility of, I think, operational procedures to write the policy notes that took this into account. In terms of why cladding systems aren't specifically mentioned in there, I think that's probably a question that's better aimed at those who wrote the policy notes. However, bearing in mind what we've just said in terms of the phrase such as, I think we did also have this issue in the brigade about not overloading staff with information and just pointing them in the direction of things to consider. But I think in terms of any deeper than that, I think those managing policy would probably be better able to answer why cladding isn't specifically in there.
Thank you for that. But bearing in mind your experience and your seniority, did you have a view yourself as to whether cladding systems or external facades should be considered by Cruz as part of the 72D visit programme?
It was never on my radar that when Cruz went to undertake a 72D, either initially or as part of an ongoing visit, that when they stood outside a building they should look at the cladding on it and make a determination as to whether it formed part of a risk assessment. No.
Even after Lachnal, that was your view, was it?
Well, Lachnal obviously had its unique issues attached to it, and certainly the panels below windows added to the fire somewhat. Organisationally, I don't think we saw Lachnal as a cladding fire in the way that you might determine Grenfell as a cladding fire. And there was other fires, obviously, Shepherd's Court, where there was cladding, and fires where spandrel panels had caught alight. So we were alive to the fact that they can add to the fire, but not necessarily seeing them as issues to put them in their own category as a cladding fire.
If you didn't see Lachnal as a cladding fire, I mean corporately as the LFB, what did you see Lachnal as being?
I'm not sure I could describe it in terms of a particular pigeonhole type explanation, but certainly Lachnal, or the fire at Lachnal, had some unusual aspects to it. One of the main ones being that the fire travelled downwards. But so I wouldn't really determine it in particular ways. I'm not saying cladding is not involved in Lachnal. Clearly it was, but I think to call it a cladding fire would be misrepresenting what Lachnal was.
Bearing in mind that answer, can we just go to a letter that former Commissioner Dobson wrote to Sir Ken Knight when Sir Ken was the Chief Fire Advisor. And that letter can be found at LFB 00104291. Now, that letter is dated the 14th of December 2009, and in broad terms it raised concerns about the use of combustible cladding panels at Lachnal, and which Commissioner Dobson indicated the LFB were concerned might well be present on other high-rise properties. Now, first of all, is that letter familiar to you? Have you seen it before?
I have seen it before, yes. I wasn't involved, I don't believe, in the construction of it, but yes, I'm aware of it.
But is the practical effect that, notwithstanding that Commissioner Dobson was moved to write to Sir Ken to highlight the problem of cladding, particularly in the context of high-rise buildings, nonetheless it wasn't something, to use your phrase, that crossed your radar as something that had to be emphasised to 7.2D crew visits?
So could you rephrase that question, please?
Yeah. Commissioner Dobson has seen fit to write to Sir Ken Knight in his capacity as Chief Fire Advisor to highlight the problems posed by cladding, particularly on high-rise buildings. Now, given that, is it still your position that the risks posed by cladding on high-rise residential buildings was not on, quote, the radar, close quotes, in terms of giving advice to crews attending to visit high-rise buildings for the purposes of Section 72D?
Okay, there's a couple of answers to that. So I think it's quite right for the Commissioner to inform Sir Ken Knight of the issues around cladding involved in Lachnal, because, as I've said, there clearly were issues. It's the definition of the fire in terms of how we describe it, I think, is more I would question. Crews were aware of the issue of cladding as a result of Lachnal, the Lachnal House presentation and the training that we did to crews, and the specific training over and above that we did with borough commanders clearly exposed that issue. I think the issue for crews in terms of being on their radar, it's their ability to be able to determine whether looking at a building on a 7.2D visit involves cladding that may be an issue, because it goes outside of the remit of their ability and training to be able to do that.
Can we look at the substance of this letter? And we start with the first paragraph, where Mr. Dobson stated this: I'm writing to inform you that as part of our investigation into the fire at Lachnal House, we have had tests carried out on the exterior wall panels of the building, and that those tests have given rise to concerns which may well be relevant to other high-rise premises. Although our investigations are continuing, and the matter is still to come before the coroner, I feel that it is in the public interest to draw the issue to your attention so that the matter can be discussed within the department and any necessary advice can be given to owners and landlords of high-rise buildings. And then if we can go to the third and fourth paragraphs on that page, Mr. Dobson sets out the functional requirements of approved document B4, before he goes on to say over the page in the third, fourth and fifth paragraphs, this: based on the tests conducted by the Building Research Establishment, it appears that there are external wall panels at Lachnal House that do not have the necessary reaction to fire properties required for the location in which they have been used. We have also become aware that this type of panel has been supplied by more than one company. In the circumstances, we believe it may be appropriate for a warning to be given to housing providers that it would be advisable to check the specification for external wall panels in their high-rise housing stock and check that what has been installed meets the correct specification, i.e. that fire safety requirements of the building regulations were taken into account, and to include this in fire risk assessments for relevant properties. Now, did you either at the time of this letter was sent or later consider whether operational crews should be directed expressly to look out for the presence of cladding or facade panels on high-rise residential buildings as part of their Section 72D visits?
No, because there were various other issues in train to deal with this. So the borough commanders were well aware of the issues, having seen the presentations, the detailed presentations by David Crowder. Then there was toolkits being sent out by Fire Safety and the Deputy Commissioner in terms of local authorities to use. So we were pitching it at a strategic level so that the appropriate people could be aware of this. Going back to for firefighters to check, it wasn't an expectation that they should get involved in that level of detail on an external wall of a high rise.
It could have been, though, pitched at a practical level, couldn't it? Simply by including the word cladding systems at the 12th bullet point on Appendix 1 of 633, so that they were at least alive to the need to look out for cladding systems, which may have an effect on fire spread in the event of a fire.
But even if we had have done that, then there would have been questions in terms of, well, exactly what are we looking for? How are we supposed to determine whether one piece of cladding is any different to another? How do we know if there are voids? What do we know about the construction of it, etc.? But apart from that, firefighters, I would suggest, well, I know, were well aware of the issues of cladding in terms of firefighting, and within their knowledge and experience that if a fire escapes a compartment externally, then there have been some occasions where cladding has become involved. So they were aware of it, but there's a difference between aware of the potential and then knowing how to look at something and determine whether it has the potential to become involved in a fire over and above any other type of cladding.
Now, did anyone else at the LFB seek to discuss with you the need to direct operational crews to have regard to cladding systems as part of the 72D visit programme?
Not that I can recall.
After the Lachnal House inquests, which had established that the panels were not of the requisite standard and had contributed to the speed of the fire, did anyone raise with you again the need to direct crews explicitly to the need to look at cladding systems?
Not that I can recall, no.
Did Shepherd's Court fire in August 2016 prompt any consideration whether crews ought to be expressly directed to look at cladding as part of the 72D process?
Not that I can remember, no.
You touched on earlier on in evidence the involvement of the responsible person on fire safety visits. Now, the Phase 1 report concluded that crews who carried out 72D visits at Grenfell should have obtained information about the building's cladding system from the TMO directly. Would LFB crews normally have made inquiries of the responsible person before or after conducting 72D visits?
When crews conduct a 72D visit, when they make the arrangement, just out of sheer courtesy, if nothing else, there's an expectation that they would contact the responsible person to let them know that they are coming, and that responsible person ideally would join them on the visit and answer any questions and show them any particular issues that they need to be able to complete the premises risk assessment.
So the answer is yes.
Yes.
Was there any system for monitoring the quality of 72D visits and the information they were collecting? I.e., were they collecting the information that they needed to in order to discharge the duty?
Yes. So a crew would, having completed the premises risk assessment, would then come back and they would get onto the operational risk database. And they would put the information in there. If there was any hazard information, they'd fill that section in. And if there was any tactical plan to be considered, then they would fill that in as well. Once they'd done that, then it sits in what's known as a work queue, and the station manager needs to quality assure that and make sure the station manager is content and satisfied that the visit has gained the necessary information. If they're not, then the station manager would send it back to the crew to do what needed to be done. Once the station manager had quality assured that, it then got sent up to information management, the people who owned the operational risk database. And this is why I made the distinction between collection and application, because there is another big part of it in terms of owning the database, which was information management. And they would quality assure the information as well, make sure they were content with it.
If I can stop you there, how does the station manager go about discharging the quality assurance function? Say, for example, we found at Grenfell that there were several errors
Yes.
in relation to the information that was recorded, as basic as not correctly recording the right number of floors, for example. How can the station manager assure himself that basic information is correct other than going out there and inspecting the building himself? How do you see him discharging that function?
Well, I mean, that's a good point. And the station manager, as I did when I was a station manager, would be expected to actually go and sample some of the visits that are being carried out. And the station manager managing the 4 watches would get a feel for the level of expertise and professionalism on the watches, and it may well be that he or she needs to make visits accordingly.
Could I, what policy direction, let's confine ourselves to policy first of all, were station managers directed to carry out this sampling exercise you've referred to?
Well, I introduced something called service standards. So one of the challenges that I have faced and the London Fire Brigade faced is that it's a vast organisation. The size of some of the 4 areas in London are bigger than most other fire brigades in the country. So, we could argue that we were managing 4 separate fire brigades. Some boroughs were bigger than some fire services in the country. So we needed standardisation and consistency. The matrix is one of those ways of achieving that, but service standards was another way.
Can I cut through this? Was there a specific provision in the service standards or any other policy that directed station managers to conduct a sampling exercise to verify the accuracy of information collected by Cruz as part of the 72D visit?
As far as I'm concerned, Service Standard 8, which was about contingency planning, advised station managers to sample the accuracy of visits as well as quality assuring from a desktop. And it was also something that I would make sure, again, at these borough commander meetings, and I'll probably over-mention these during the next few days, but they were absolutely vital to the information flow between the strategy of the organisation and the application at local level. And I'll make it clear there as well.
Was the sampling exercise defined by the risk presented by particular properties? So the station manager's quality assurance programme would concentrate on high-risk buildings?
The quality assurance in terms of desktop was for all buildings. Every single building that goes on the ORD.
But would the sampling exercise be prioritised and focus on accuracy of information in relation to high-risk buildings?
Not necessarily.
No. Again, would be subject to the individual discretion of a station manager, would that
Yes.
be right? Now, can we look briefly at the LFB's Lachnal Assurance Review, which can be found at LFB 0004801. And this document summarises the required actions identified by the LFB following the Lachnal fire. And it also includes the recommendations made by the coroner. Now, if we can go to page 28. It deals with Section 72D visits at high-rise premises and actions taken specifically in response to the coroner's recommendations. And if we can see the second full paragraph on the left-hand side, which says this, a review. A review of the operational risk database shows that on average approximately 40 visits to residential high-rise premises that were not yet recorded on the operational risk database were completed each month under the requirements of Section 72D of the Fire and Rescue Services Act, resulting in the production of an electronic premises information plate for those premises. Note, data between April 2014 and October 2017. Using the same data set, i.e. as of October 2017, it was identified that approximately 1,700 residential high-rise premises had premises risk assessment recorded against a total of approximately 6,900 residential high-rise premises in London.
Mr. Kinnear, I think it would help if we could scroll off a bit, or rather scroll down.
We scroll down a bit further, I think.
Further, I think, please.
So I was assuming the scrolling was following me.
Yep, thank you very much.
Thank you. I'll let you read that, Mr. Brown, before I ask a question.
Okay.
Now, I'm mindful that those numbers 1,700 and 6,900 relate to October 2017, i.e. after you retired, but are we safe or reasonable in assuming that the figures would have been broadly the same during your time at the LFB, i.e. in terms of total number of high-rise properties in London and those that had had PRAs conducted?
Well, the only thing I would say about that was I remember in September 2013 a presentation which we may well discuss at some point. And in there we highlighted there was 1,300 high-rises on the operational risk database. And that was in September 13. So 4 years later, more or less, only an extra 400 I find surprising and mathematically incorrect if 40 visits per month were being undertaken, then one of those figures is wrong somewhere.
Well, some of the data set post-dates your retirement, so
Yes.
I think we just have to bear that in mind. But if we can
Yeah.
take these figures at face value, they show, or seem to show, that 1,700 high-rise premises were on the ORD
Yeah.
and subject to scheduled Section 72D visits, it would follow.
Yeah. I guess what I'm trying to say is that I would have expected there to be more than 1,700, but taking that at face value.
Let's.
Yeah.
It's unfair on you because you're not in a position to verify the data. We have to take this at face value. So we've got there 1,700, which would be on the ORD and therefore subject to scheduled 72D visits. Is that right?
Yes.
And looking at the figures we've got here, that would mean that 5,200 high-rise premises were not on the ORD and so therefore not subject to scheduled 72D visits.
But based on these figures, yes.
Now, would it have been a source of concern to you, let's assume these figures were whilst you were still in post, would it be a source of concern to you that more than 5,000 high-rise properties were not on the ORD and were therefore not subject to scheduled 72D visits?
Absolutely, and it was a concern of mine when I was in post, and it was one of my many things that we were trying to improve. So there was clear instruction given to station-based staff and borough commanders and processes and procedures put in place that we could increase that number. My utopia was that every single high-rise premises in London would have been visited and been risk assessed. Whether it stayed on the operational risk database after that visit was another issue, but we needed to have carried out that visit and a premises information plate been created and installed.
Bearing in mind that answer, was the position therefore there was a similar disparity during your time as Director of Operations between the number of high-rise buildings that were recorded on the ORD and subject to 72D and those that which were not?
It's true that there wasn't every single high-rise on the ORD, but it's also true that we were working really hard to rectify that, and we was aware of the issue.
I'm sorry to interrupt you, Ms. Brown, but it's not just that not everyone was recorded. The fact here we've got a disparity, 1,700 were, more than 5,000 were not. Now, my question is, was that same proportion of disparity the case when you were Director of Operations? A similar order?
There was a large number of high-rise that weren't on there. Without wanting to split hairs, I also want to alert the inquiry to the fact that we had a real challenge and it might seem strange, but in finding out exactly how many high-rises there were in London. We did an awful lot of work in trying to actually determine that, talking to local authorities, housing providers, and we could never get a complete straight answer. So we was never entirely sure how far we were away from achieving our objective. But yes, there was a significant amount that weren't on there, but we were aware of that and trying to rectify that.
Ms. Brown, we will come on to that subject in due course. So it's 11:15. Given where we're at in the examination, that's a convenient time.
Yes,
your permission.
right. All right, well then that sounds like it's a good point at which to have a break. Well, Mr. Brown, as you were told earlier, we have a break partway through the morning. We'll take that break now. We'll resume, please, at 11:30. And I have to ask you on this and every other occasion on which you leave the room please don't talk to anyone about your evidence or anything relating to it while you're out.
Okay, thank you.
Thank you very much indeed. Would you go with the ushers then, please? Thank you. 11:30.
Thank you.
Would you ask Mr. Brown to come back in, please? Right, Mr. Brown, ready to carry on?
Thank you, yes.
Good. Thank you very much. Yes, Mr. Kinnear.
Thanks, sir. Mr. Brown, can we turn now to your email to LFB stations sent on the 20th of April 2009? And it was sent on your behalf, and you deal with this email on page 15 of your first witness statement. And if we go to LFB 000-321-66/15, and we see at paragraph 43, you say and cite this email as being an example, and following on from your earlier evidence, of the importance the LFB placed on pre-planning for residential high-rise fires. Now, if we go to the email itself, which can be found at LFB 000-321-61, and we see at the bottom of page 1, the email says at its head, and I quote, "This message is from AC Brown, Service Delivery and Mobilising, and is for all station-based station managers and borough commanders." And it deals with section 72D visits at the top of page 2. And it says this: "A database of high-rise premises, see attached, has been compiled that falls within the criteria set out by AC Web Ops Planning in April 2007, so roughly 2 years before, which defined a high-rise as a domestic residential premises which is fitted with A, firefighting lift, and B, dry or wet rising main. As part of the ongoing familiarisation training for station-based staff, station managers are to ensure that watch and crew managers diarise, book and visit the high-rise premises on their station's ground during 2009-10. This process should begin with immediate effect and then be undertaken annually thereafter. Borough commanders should liaise with their DAC to discuss prioritisation of these visits." First of all, do you remember that email?
I do, yes.
Now, at first blush, your instruction appears to be a direction to visit all high-rise premises on a station's ground annually. Is that a fair reading of what you intended?
Can I just read it again?
Of course.
So there was a database that John Webb Ops Planning had prepared, and we wanted staff to look at that. So whether I mean by that all the high-rise that was on that list prepared by John Webb, or whether I mean going above and beyond that in terms of all high-rise, I'm not quite sure. But ultimately, yes, I would have expected all high-rise to be visited. And yes, at that point, it would have been annually.
And looking at really what you say in that paragraph at the top of page 2, you say station managers are to ensure that watch and crew managers diarise, etc., the high-rise premises on their station's ground.
Mm-hmm.
Now, that suggests all high-rises on a particular station's ground. Would you accept that?
So where is that exactly?
Top paragraph,
Yeah.
third line.
Ah, yes. Yeah, absolutely. But as I say, whether it referred initially to high-rise, it was on John Webb's email and on their station's ground or not, I can't quite recall. But I would accept that ultimately, yes, we expected that all high-rises on their station's ground would be diarised and visited annually.
Can you help us? What was the reasoned basis for the annual requirement for crews to visit all high-rise premises on the station ground?
I think probably at that time we wasn't quite sighted on the number of high-rises that were available, and we felt that that would be an appropriate and not an unreasonable expectation. That was back in 2009. I think once the enormity of the task became more apparent, then we took more of a risk-based approach, as we saw with the premises risk assessment.
Before you sent the email in April 2009, did you consider or take advice about whether it was reasonably practicable for all high-rise buildings on a station's ground to be visited annually?
I don't believe so.
So really the underlying intent was a scoping exercise to identify high-rises and then take it from there. Is that a fair summary?
Yeah, there isn't a way I would have considered describing it, but yes, that's not an unreasonable way to describe it.
When you sent this email, was there a plan to monitor how the aim of annual inspections was to be achieved?
Well, yes, but that plan would have been what I would describe as normal business. So we were forever monitoring, performance managing, overseeing progress in terms of making sure that what we wanted to happen was happening, and then fitting in other objectives as well.
Now, can we look at the database that was referred to in your email? And that can be found at LFB 00104535. Or is this document will need to be downloaded, so there may well be just a bit of a delay. There we go, thank you. Do you remember providing or reviewing this document before it was attached to the email that was sent in your name?
Well, I don't remember doing it, and to be honest, I don't think I did. This was prepared by Ops Planning, and I've taken this on face value that it was properly checked, and I've attached it there as guidance to station-based staff in terms of in case they weren't aware of some of the premises.
Can you help us as to where the list of properties came from?
I'm afraid I can't. I've thought about that in readiness for this inquiry, and it was prepared in very early tenure of mine by a colleague in Ops Planning, and I don't know where they got that information from.
And so you don't know what criteria they applied in determining?
Well, I can only imagine it was a criteria that I put in that email in terms of dry riser, etc. But other than that, I don't know.
But that's an assumption.
It is an assumption, yes.
Okay. Can you remember, how was the database to be managed if this was the database?
Well, it was on the Central Risk Register, which was the forerunner of the Operational Risk Database. So the idea, for want of a better term, was to cleanse the Central Risk Register, and the premises on here would find their way onto the Central Risk Register or the Operational Risk Database, whatever was in process at the time.
So who would be ultimately responsible for managing this database?
This actual database I'm looking at now?
Yes.
Well, once it got onto the Operational Risk Database, it would be information management.
Thank you. Now, can we look at the draft amendments to the high-rise policy 633 that were circulated in 2010? And for that purpose, can we go to an email sent by Peter Coward, which can be found at LFB 00082695. Now, as you can see from the top of this, Mr. Coward emailed James Knighton in relation to a draft version of 633. You were not included on the email chain, Mr. Brown, I should make clear. And his email is set out there. I'd like to start at the fourth paragraph, where Mr. Coward said this: although I believe the current draft represents a significant step forward, there remain a number of key issues and points that I believe require further work and consideration. These include, and if we go to the second bullet point, the feasibility of station personnel visiting all high premises on their station's ground, as this is a very significant task, especially for central London stations. I fully understand why we would state that in policy, but it may be worth giving this statement further consideration. Have left it in for now. Now, that second bullet point appears to be a reference to paragraph 3.1 of the draft policy 633, which was attached to this email, and we can see that draft at LFB 00039485. And if we go to page 4 of the draft and paragraph 3.1, And what that says in the second sentence is this: station personnel should be familiar with all high-rise buildings on their ground. Now, Mr. Callop appears to have interpreted policy as requiring stations to visit all high-rise premises. Was that how paragraph 3.1 was being interpreted generally across the LFB at the time, or is it a policy aspiration?
I think it's both, really. But personally, I was always of the view, and I made it absolutely clear, I cannot see from a moral or professional perspective that we could exclude any high-rise. So if any building needs inspecting, then we should inspect it. Whether it led to further and ongoing inspections is another issue. But for me, my position was that over a period of time, every single high-rise should be visited.
Were you aware at the time that Mr. Carrop had reservations about the practicability of visiting all high-rise buildings on a particular station's patch?
I wasn't, no.
Had anyone else raised that concern with you at the time, or indeed afterwards?
I don't recall anyone raising the issue with me prior to. In terms of afterwards, there was extensive pressure that I applied to my own staff to achieve this objective, and yes, I then did get feedback from a range of sources how challenging this was, and I accepted, and I accept now it is challenging. But for me, that's not a reason not to do it.
Were you asked to contribute to this particular review of 633?
Personally, no, but it would have been standard practice that heads of service would have been involved. If I had have received an email on it, I invariably would have passed it on to people that work for me, most probably Central Service Delivery, as they were called at the time, and they would have commented on it on my behalf.
You don't remember expressing your own views personally about the practicability of annual visits?
Not at this time, no.
Now, in 2015, policy.
Sorry, if I can just clarify there. So, the annual visits issue, no. The concept of all high-rise being visited per se is they're two separate things.
You've made that clear.
Yeah.
Thank you. Now, in 2015, Policy 633 was again updated and the new version published on the 1st of June 2015. And that can be found at LFB 0001256. And if we can go to page 7 and section 4, you can take it from me that the paragraph 3.1 of the previous draft, which required station personnel to be familiar with all high-rise buildings on their ground, had gone. Now, were you consulted about that particular change?
Not that I can recall.
Again, can you remember whether you were involved or consulted as part of the revision process for this particular iteration of 633? And by you, I mean you personally.
Other than the well laid out practice that I've just explained in terms of heads of service of consultation, I don't specifically remember.
Are you able to assist the panel as to whether omitting what previously been para 3.1 was a deliberate change in policy to downgrade the regularity of visits?
I'd be speculating if I was to say yes or no to that.
I'm not asking you to speculate, but mindful of your previous evidence, you said that members of your staff had forcibly emphasised to you the practical difficulties confronting annual visits to high-rise buildings. Is that a fair summary?
It wasn't only members of my staff, it would have been in discussions with staff side as well, because I introduced certain practices that would enable staff to be able to achieve the objective of visiting all high-rise, which wasn't necessarily popular with staff side.
Could we now turn on to operational news, and it's the edition number 20, which was an article published in November 2011. We can find this particular edition of operational news at LFB 000 And we can see there on the front page it contains an article entitled High-Rise Firefighting, the first few paragraphs of which are the text immediately below the photograph under the heading for high-rise firefighting, and it addresses the issue of pre-planning. Now, the Operations Directorate Coordination Board, I think you were a member, were you? Is that right?
That's correct.
Now, they were responsible for articles published in operational news, is that right?
That's right, yes.
Who within ODCB was responsible for the content of articles published?
It depended on who was the subject matter expert. So dependent on that particular subject, we would look at the section within a department that concentrated on that area, and they would have been the author, original author of each aspect. So this particular article probably would have come from somewhere within Ops Policy or Ops Assurance.
So can we take it from that you weren't involved at all in the drafting of this article? Would you have been consulted about the contents of the article?
Once the article was written, it would then be circulated to various people, which may or may not have included me, dependent on when it was. Certainly when I was a Director of Operations, so after April 15 it would have done. Prior to that, possibly not.
Is it right that the content of articles is a matter that would have been discussed at ODCB, and so they were the ones who agreed content, and so you would have been aware, at least from ODCB meetings, that this article was being published?
Well, at ODCB meetings we would have determined the need for an article and an associated training package, but then after that point and the article was written, it wouldn't then come back to ODCB for approval. And it'd be the fact that it was being written. They knew the parameters in which it needed to be written. Communications team had a big part to play in terms of presentation and fitting in within a certain size of the document, but it didn't come back in a loop for final approval to ODCB before we published.
But you're aware in broad terms of the topic was going to
Oh, absolutely, yes. Yeah.
Now, if we can look at the article itself, and if we can stay on this page and look at the middle column underneath the photo, where it says this: any visit to a high-rise building should be used as an opportunity to pre-plan. This will include the location of the LFB premises information box, if fitted, as well as the accuracy and completeness of information provided, including evacuation plans. Any high-rise buildings which pose a particular risk should be subject to 72D visits. Now, looking at that last line, any high-rise buildings which pose a particular risk should be subject to 72D visits. That appears to be a departure from the terms of your April 2009 email, which required all buildings, high-rise buildings, to be inspected. Was there a conscious departure, therefore, in the Operational News issue 20, away from the inspection of all high-rise buildings that you'd encouraged or directed in your April 2009 email? Can
you just remind me, please, of the date of this Ops News article?
Yes, it's November 2011.
Okay. I think there's a subtle difference here. I don't think it is a departure. I think the 2009 email was about making sure that every premises had been visited to determine whether it needed to be included on future 72D visits. What this is saying is any high-rise buildings, which I would add, having been initially inspected, pose a particular risk, should be subject to future 72D visits. So the concept was and remains, as far as I'm concerned, that no building can never be not inspected, because that initial inspection determines future inspections.
And so this should not be read as a reflection of the concerns that Peter Cowap had raised.
No, absolutely
about the practicability of Section 72D visits.
Yeah. So we need to know what is out there, and once we know what is out there, we can then decide in terms of risk assessment whether it requires ongoing visits.
Are you able to help us as what was meant by the phrase posed a particular risk?
I would suggest that's just a broad terminology to reflect that there's a whole range of different risks that you might experience in any building or in a high-rise.
And again, there would be an element of discretion exercised by the station manager based on his knowledge of the features of a particular high-rise building.
Up until the point that we introduced a premises risk assessment, which made it far more prescriptive and consistent.
Thank you. Now, can I turn to a separate and distinct topic, which is the introduction of Policy 800 in 2012. Now, as we've seen previously, it was first issued in July 2012, and its stated purpose was to assist station personnel with the risk assessment process for sites in their area. Now, I think as we touched on earlier, you were the lead senior officer in relation to the introduction of 800, though particularly in relation to Action 2B. Now, one thing I'd like to look at is that particular action for which you were responsible, which was to create an inspection regime targeted at high priority buildings. Now, were you the lead for the first introduction of Policy 800 or only for the later version? It seems to be, I think, the later version, given what you said earlier on.
That's right, yes.
Can you, who was your predecessor as the lead on formulation of the policy?
I think it was operational assurance. Operational resilience. That's right. I think it was operational resilience, and at that time, I know Tim Cutbill was the Assistant Commissioner for Operational Resilience at some point. I'm not sure where he was at that time. I can't recall exactly who that person would have been.
And in summary, what were the responsibilities of the lead in relation to 800?
Well, the lead really would have been making sure that the policy was fit for purpose and that it was reviewed periodically as and when it was scheduled to be reviewed. In terms of the specifics within it, the lead would have delegated that to members of their staff.
So you weren't involved in the substantive drafting process? No. Now, as we've seen, Policy 633 included a list of items which Cruz should consider when carrying out Section 72D visits at high-rise properties. Why was that list not included in Policy 800 so as to give comprehensive advice as to what Section 72D visits should be directed to?
I don't know for sure, but in saying that, there was a view within the organisation that we wanted to keep policies, say, to a minimum. We had too many policies at one point, I think, and we wanted to rationalise our policies. We wanted to make sure our policies didn't overburden staff with too much information, and that they just did what they needed to do. So I can only imagine that there was, to avoid duplicating lists, just a mere reference from one policy to another was sufficient.
Following on from that, though, there's no reference in the 2012 iteration of Policy 800 to the guidance in Appendix 1 of Policy 633. How were Cruz therefore to know whether to cross-refer to Appendix 1 of 633 in the absence of any specific reference?
Well, if there wasn't a reference, then that's clearly an omission, and that's something that hopefully has been remedied now. All I would say is that Policy Notes 800 and Policy Note 633 to do with information gathering and high-rise firefighting was such a component part of a firefighter's role that they would be aware of both. But in saying that, it is, if it is the case that there isn't any reference at all, then that's certainly something that was that shouldn't have been the case.
Now, would you accept, am I putting this too simplistically, that because there was an absence of a cross-reference in the policy, there was at least a risk of Cruz missing or not being directed to securing relevant information as part of Section 72D visits?
I can see why you would say that, but all I would say is high-rise firefighting has always been high on the agenda of firefighters. So I cannot imagine that they wouldn't be aware of what they needed to do under Policy Note 633.
Would it be fair to say that the risk of information not being caught was not identified at the time that 800 was issued in July 2012?
That's not an unreasonable way to describe it.
Can I now turn to a separate and distinct topic which concerned the incident at Salamanca Place in July 2011? Now, Salamanca Place was a high-rise building in Lambeth, wasn't it? Or is?
Yes.
And if we can look at the Senior Accident Investigation Report in relation to that incident, which is at LFB 00102299. Now, we are proceeding on the basis that although this is watermarked draft, it is in fact the final version, and that basis, so people know what it is paragraph 55 footnote 4 of Mr. Cowup's third statement, which can be found at LFB 00119849/28. First question, Mr. Brown, is do you remember the Salamanca House incident, or Salamanca Place incident?
I don't remember it well, but yes, I do recall it.
In summary, a crew attended a fire incident on the 15th of July 2011. During the incident, 4 firefighters became trapped in a lift, exposed to heat and smoke before being rescued by colleagues. Are those the pertinent details?
Yes.
Now, in summary, this report was the culmination of the SAI process, which involved the investigation of safety events. Is that right?
Yes.
And SAI stands for Senior Accident Investigation.
Yes.
And its purpose is to examine by senior and specially trained LFB personnel to identify any underlying systemic failures that might have led to a safety event occurring during an incident.
Yes, and to aid organisational learning to prevent it reoccurring.
Thank you. Now, is it correct that such an investigation concludes, or should at least conclude, with an action plan which sets out the measures that the Brigade intends to take to address any deficiencies identified?
It will be normal practice, yes.
Now, during your time at the LFB, SAI action plans were monitored by Operational Directorate's Coordination Board. Is that correct?
Yes, and we would add a rolling log of various actions under SAIs, and we would add new ones to it to make sure nothing was lost.
Thank you. Now, the SRI report for Salamanca Place is on the screen. If we could turn to page 7. There you see, roughly the top third of the page, the heading Pre-Planning. And what it says from the end of the second line is this: the building was not on the Brigade's central database for high-rise buildings, and a Fire and Rescue Services Act 2004 Section 72D visit had not been carried out by the watch involved. Now, the report then goes on to set out relevant pre-planning policy provisions, including 633 and 521. And if we turn over the page to page 8, now we can see the text in italics is your email of April 2009 to station staff about the database of high-rise premises and the need to carry out annual visits to high-rise buildings on a particular station's ground. Now, if we can go to the middle of page 9, so over the page, we can see there the heading Pre-Planning Analysis, and that states this: and if we could expand it in such a way so that notes GR3 and GR4 can be seen by Mr. Brown and the panel. Thank you. The pre-planning analysis says this: there is evidence that the crew at Lambeth were aware of the premises and that there may be access difficulties. The opportunity was not taken for a 72D visit to be arranged. There was a failure to carry out a 72D visit. High-rise database. It is unclear how the high-rise database is maintained or updated for new high-rise buildings. There is no clear mechanism for fire stations to be informed of new high-rise buildings which require Section 72D visits. Now, I have assumed that the reference there to high-rise database is to the database that was set out in the Excel spreadsheet that was attached to your April 2009 email. Is that a safe assumption to make?
Either that or they're referring to the electronic database, either the Central Risk Register or the Operational Risk Database.
Thank you. Now, we can see the comments on the side GR. Is GR Gary Reason?
I would imagine so.
And what he says in GR4 is this: it would be helpful to have a footnote explaining how stations access this database if they can. Now, that comment requesting clarification as to whether stations are able to use the database is unlikely to refer to the ORD, isn't it, given that the ORD was capable of regular and easy access?
Yes, I think by this time, I think the ORD probably had formally taken over from the Central Risk Register. So yes, it would seem reasonable that it's referring to that at that moment. Yes.
Yeah. Sorry, just to clarify your answer, what I was suggesting to you was that it is unlike the database that is the subject of the text here is unlikely to be the ORD, is what I put to you. I just want to make sure you agree with that proposition.
Oh, I see. I'm not sure we can say that, to be honest. I mean, first of all, there is, to my knowledge, there was no such thing as a high-rise database as such. They were referring to a database that contains high-rise. And the ORD, and Gary was well aware of the existence of the ORD at that time.
And it's for that reason, Mr. Brown, I suggest to you it's not the ORD he's referring to. And the other factor that he appears to have in mind, or the author of this report appears to have in mind, is the Excel spreadsheet that was attached to your April 2009 email, because that's what has been quoted extensively on the preceding page.
I'm not sure we can draw the conclusion. So if we're looking at comment GR4, i.e. it would be helpful to have a footnote explaining how stations access this database, I don't think we can necessarily draw the conclusion that Gary's not referring to the ORD. It may well be he's just trying to have an explanation. It just makes it helpful for the reader.
Okay. Now, if we can just look at these comments in more detail. The first one, GR3, said this: as the building is adjacent to the fire station, did it not occur to any of the watches that should be subject to a 72D visit, irrespective of whether it appeared on the database? Now, that comment suggests that the Cruz were not expected to use the database as a comprehensive list of premises they were required to visit. Would you agree with that? That assumes, of course, that the database is the Excel spreadsheet which was attached to your 2009 email.
I think the Cruz or certainly managers, station managers, borough commanders, I'm sorry to repeat the comment again, but I think it's worthy of clarifying how much of how important an issue it was for us. We're aware that all buildings need to have an initial inspection to determine their future inspection regime. So whether it's on the database or not, I wouldn't expect crews or managers to be led exclusively by the database, because people should have known that not everything was on that database.
And there may be cause for concern about the quality assurance process taking place if the Cruz had not identified a high-rise building immediately adjacent to the fire station.
Well, the quality assurance process that we've spoken about was assuring the quality of the information that's gone on the operational risk database once it's been inspected. The proposition here is about buildings that have never even received that initial inspection in terms of even carrying out that quality assurance. So that boils down basically to station managers and borough commanders making sure that all buildings have had that initial inspection, which is a slightly different nuance to quality assurance.
Now, the report on Salamanca Place led to the creation of an action plan entitled SAI 282 Salamanca Place. That can be found at LFB 0095042. And that plan was dated the 22nd of August 2012, so more than a year after the incident. And I'd like to focus on two particular actions. And the first one is Action 2, which can be seen in the second row in the table. And it provided thus: carry out a review of the existing high-rise database to determine whether it is viable and beneficial to develop and maintain this data set. The term beneficial relates to station staff being able to access this type of information to highlight new high-rise premises and inform 7.2D visits. Now, that action was allocated to the head of information management, is that right?
Yes.
And the third officer, which was at that time you?
Yes.
And the head of information management at this time was David Wyatt, is that right?
Yes, and still is, I believe.
Now, does that help you identify what the database was that these people were referring to? Do you think it was the Excel spreadsheet attached to your email, or was it the ORD?
I think it must be the ORD, because Head of Information Management was managing the contents of the ORD.
Was the review carried out?
To my knowledge, yes.
By whom?
I don't know for sure, but certainly I would have made sure it would have almost certainly been David Wyatt, and then maybe some people that work for me. But I can't recall any further details, I'm afraid.
Can you remember when it was carried out?
I don't remember particularly when, but all I can say is on all of these, whenever dates were given to carry out actions, I was very, I gave a lot of scrutiny, shall we say, to making sure actions were carried out when they were supposed to be carried out. So if there was a completion date on it, I'd be confident that it would have been done within that time. But I can't remember any further than that, I'm afraid.
There's no completion date identified there.
No.
So in the circumstances, what steps would you have taken to ensure the review was actually carried out?
Well, it was an ongoing transfer. So the wider picture is the CRR, Central Risk Register, was being carried over onto the operational risk database. The list of high-rise premises that John Webb had collated was another area that was feeding into the operational risk database. So it was a process, an ongoing process that was going on to make sure everything was finding its way onto the new portal, if you like, the complete database, i.e. ORD, and that we continued in making sure new premises, regardless of whether it had been on a list or not before, found its way on there.
Can you remember the substance of the conclusion of the review? Don't speculate if you can't.
No, I can't remember specifically.
Now, can we go on to an email chain that was pertinent to this action? And it can be found at LFB 0095342. And it's an email chain initiated by David Wyatt on the 22nd of August 2012. And if we can turn to the bottom of page 2, we see an email that Mr. Wyatt sent at 9:11 on the 22nd of August in respect of SI 282, so that's Salamanca Place, draft action plan. And he said this: so, the action in this plan for me, with Dave Brown, is, the database is, of course, ORD. I'm assuming, but we'll clarify. Now, if we go back to page 2, we get an email from Anna Lockwood. And if we go up the page so we can see that email. And that was sent at 9:50. And she said this: I've had a conversation with Andy O'Loughlin about this a few months ago. he was under the impression that PDA section maintained a database of all high-rise residential flats. I informed him that this was not the case. Some entries have been made in ORD, but not all. We can extract all the properties from the mobilising system, but this does take time. And if we go to page 1, and Clive Eustace's email, which is at the top of the page, he says this: I don't think it is ORD, but do think it is a very confused message in the first place. The high-rise database they refer to is, I am sure, the list sent round to stations some months, years ago, and I have no idea who owned this, but can pretty much guarantee it was never updated, and is therefore of no very limited value. This was the knee-jerk list, where the message said visit every high-rise and consider 72D, but what Dave meant was add one of the blocks in an estate if there are unusual or very difficult circumstances to be found there. He couldn't say this in an email, of course, and we, information management, therefore had to make sure people understood it at information management days. Now, that email chain appears to say that the SIA action plan was referring to the high-rise database attached to your April 2009 email. Now, having had your memory refreshed by contemporary correspondence, would you accept that?
Well, based on so Andy O'Loughlin, from what I can recall, had a lot to do with senior accident investigations. So if that was Andy's understanding, then yes, he may well have been referring to that list. But I would clarify that and say the fact that that list was finding its way onto the operational risk database. So whilst it might seem, I don't want to appear to be dancing on a pinhead with this one, but the information that was in that list was going into the operational risk database. The operational risk database was going to be the all-consuming one-stop place where all information should be. I think what this does highlight is, yes, there clearly was confusion, and part of our remit was to eradicate that confusion so everyone understood where they need to go to for information.
And so the basic position is that three plus years after you sent your email of April 2009, there was still confusion about the basics of what high-rise properties were on the books, as it were, and what the risks were arising from those properties.
No, I wouldn't agree that there was confusion about what high-rises were on the books. There may have been some residual misunderstanding that predetermines the section carried some kind of exclusive list of high-rise rather than just the all-consuming list on the operational risk database. But I don't think it demonstrates there was confusion about what was on the list and what wasn't. It was all about organisational knowledge.
So there's confusion, looking back at your earlier answers, to where to find that information, though.
Well, according to this email chain, yes, but I don't believe there was such confusion, to be honest, because the central...
I'm sorry to stop you there, Mr. Brown, because I think if there's any confusion now, it's about the evidence you're just giving. If we could scroll back, I'd understood you to indicate that you're accepting that there was confusion as to where the information regarding high-rise buildings was located. Is that your evidence or isn't it?
So, sorry, can you repeat that?
Yes. I'd understood you to indicate that you're accepting that there was confusion, as evidenced by this email chain, as to where information regarding high-rise buildings was located. Do you accept that?
In terms of whether it was located on an Excel spreadsheet or on the operational risk database, yes.
And that's the clear thrust of what Mr. Eustace is saying in this email, isn't it?
Well, he certainly says in the opening sentence, I don't think it's ERD, but it's a confused message. Yes, he does say that.
Now, when he says in his email, he refers to a message that's said visit every high-rise and consider every 72D. That appears to be a reference back to your email of April 2009. Would you accept that?
Yes.
Now, Mr. Eustace described that list as a knee-jerk list. Now, first of all, do you accept that proposition?
No.
Can you remember what event might have triggered the knee-jerk to which Mr. Eustace is referring?
Well, that's why I wouldn't agree with it, because I don't think there was such an event. I think the rationale behind the 2009 email was the fact that we become more organisationally aware. There was an Ops News that had gone out not long before talking about high-rise. There was another Ops News coming out about a month later after that particular email. There was the operational risk database being formulated. There was mobile data terminals about to come online, which displayed the information to Cruz at an incident from the operational risk database. So there was a number of things going on. And then there was the ongoing, and I can't underline this enough, there was the ongoing at the forefront of our minds about the importance of high-rise for various reasons.
Sorry to interrupt, was it a knee-jerk to the impulse behind your email of April 2009?
No, I wouldn't accept it was impulsive or it was a knee-jerk
I'm not
reaction.
suggesting it was impulsive. What I'm suggesting is that the trigger for the knee-jerk list was your underlying motivation for sending the April 2009 email.
The fact that a list existed certainly underpinned the email, but it wasn't the motive for doing it. There was a range of other organisational things going on.
Okay. Mr. Eustace says in that email, and we can see there the message said visit every high-rise, but what Dave meant was, and he sets out there what he understood you to be saying. Now, is Mr. Eustace correctly summarising your true concern in that email?
No.
From where could he have got that impression, do you think?
I don't know. I think that's something that only Clive would know himself. But it was common knowledge that there were certain housing estates where there might, and I can think of one in particular in East London, where there's 12 high-rise blocks and they're all absolutely identical to each other.
What were IM days?
IM days were something that Clive Eustace and his team would run, and we would invite borough commanders and station managers up to headquarters, and then Clive and his team would go through with them all the various technological support systems, ORD for one, for example, station diary, outside master duties list, that station managers and borough commanders can use to make their role a lot easier and more efficient.
What guidance was given to the Information Management Department to allow audience members at these IM days to know what constituted unusual or very difficult circumstances?
I don't believe these days would have covered that kind of area, because that wouldn't been the remit of what an IM day was. An IM day was to know how to use the information management systems that were in place.
Now, can we look at the 4th and 5th paragraphs of Mr. Eustace's email? And he starts with this: it has been a constant battle with some SMs, presumably station managers, insisting they've been told to add all 200 odd high-rises they have as visits in the station diary, OSD, so it's, I think, outside scheduled diary, is that OSD?
I think it's outside duty master list. I'm not sure what the S is for.
Which adds them to ORD, of course. It is now back again, but it's exactly the same issue. People cannot add all high-rise blocks on their ground to MDT via ORD, as they would have no time to visit them all, and it would be of very little value anyway. The ones that are dodgy, upside-down maisonettes, DR, so dry riser outlets, only on alternate floors, etc., should already be on. If we had a complete list, we could add as an overlay, of course, but this is valueless, apart from ticking a box, unless the data held specific things. Saying there is a large high building here on MDT is pretty pointless when they're outside it and can see that, etc. Now, where Mr. Eustace says there's been a constant battle, Were you aware of a constant battle, or at very least concerns raised by station managers as to the practicability of adding all high-rise buildings?
I wasn't aware of issues from station managers at that time. I think, as I said earlier, once we put our systems in place to make sure every high-rise and every building was visited, then we did get some pushback, feedback in terms of at least how we're going to achieve that. I have a vague recollection of Clive being concerned in the issues that he's raising, but then he was coming at, understandably, from the point of view of managing the database and then the quality assurance issues that go on there. And I understand his position, but my position was, and for what it's worth still is, that every single building should be visited, because just because, and I use that example of this housing estate in East London, there are 12 high-rises that are identical. The people that live in them aren't identical, and the risks therefore are not identical. And you could have a hoarder in one of those 12, and you could have a different risk in another. So you need to visit every single one. And once you've done that, if having done that, you can then determine that they remain identical, then maybe we can move to the position that Clive is talking about. But up until that time, my position was firefighter safety. It was extinguishing fires, gathering information, and you can't make assumptions on that regard.
You said you were vaguely aware of the concerns that prompted Mr. Eustace's email. Were you concerned as a result of those matters which were exercising him that Cruz might be taking inconsistent approaches to which high-rise buildings to visit, etc.?
Yes, Clive, understandably, a professional officer, likes things done properly and was very protective and of this new database, operational risk database, and he wanted it to be a clean and efficient and effective database, which is what I wanted too. Yeah. But I had a lot to do with Clive, and so therefore, in the margins of normal meetings, yes, I would be aware of Clive's views on this.
We're sort of, as we discussed earlier on, 3+ years on from your April 2009 email, and the position may not have materially improved. Did Mr. Eustace communicate his concerns to you more directly at this time, and if so, what action did you take to try and expedite the improvement of how you held knowledge in relation to high-rise buildings?
From what I can recall, Clive's concern was that we were putting too much information on the ORD, whereas my concern is that I wanted to make sure everything was inspected and the appropriate information went on the ORD. But I think where we both agreed is that the premises risk assessment would be that appropriate system to satisfy both of our concerns.
Now, let's focus on that and looking at the practicability of it. Mr. Eustace said people cannot add all high-rise blocks in their ground to MDT, as they would have no time to visit them all, and it would be of very little value anyway. Would you agree with the first element of that proposition, that Cruz did not have time to visit all high-rise blocks on their station's ground?
Well, firstly, it depends on the station's ground. Some stations' ground has significantly more high-rise than others. And if you was to look exclusively at the Cruz on some stations' ground, let's take, for example, in Tower Hamlets, there's a predominance of high-rise. If you was to say to the Cruz in Tower Hamlets, it's your job to visit all those high-rises and your job alone, then yes, it will be a very challenging task. But that wasn't the approach that we took.
And I suppose the more pertinent criticism is the second one here, that he said it would be of little value anyway. I think it would benefit the panel to have your views on that particular criticism he made. Do you accept that that exercise would have been of very little value?
No, I don't, because I think what Clive is referring to is on the assumption that nothing changes and that all high-rises within that particular area or estate are the same. But we can't make that assumption. It would be dangerous to make that assumption.
Is there a problem that, been thinking about matters practically, that if you do require Cruz to visit all high-rise buildings, and I'm mindful of your sensible caveat that depends how many there are, etc., there's an element whereby they go round them in order to tick that particular box. but actually the purpose of the Section 72D would be undermined because they're not doing the job properly, examining all the matters they need to examine in order to collect all the information the law requires them to gather.
I can see why someone might say that. I would counter that with saying that this contradicts their professionalism. And what I always used to say to crews at stations at every opportunity is, you're carrying out this inspection, this 72D inspection, because one day you might be called to go in there and risk your life and fight a fire. And so it's for your own benefit and your family's benefit to make sure you've got all the appropriate information. So I don't think any sensible professional firefighter would overlook that, because they know that tomorrow they could be in there fighting a fire and they might miss something that could save their life.
Put slightly differently, were you given any substantive evidence that suggested or indicated that the value of Section 72D visits of high-rise residential premises was being debased, or was it materially insufficient as a result of them having to inspect all high-rise buildings on their ground?
I wasn't made aware of any specific issue that would underpin that statement. I guess I could look at the number of high-rise buildings that were becoming involved in the operational risk database and recorded, and they weren't being loaded on as quickly as I would like. So that caused me some concern. But I was satisfied with the various quality assurance processes we had in place to make sure that the quality of the information was correct, notwithstanding the comments you'd made earlier about that on Grenfell.
So at the risk of oversimplification, there were no red or amber signals flashing to you that the quality of information obtained through Section 72D visits was materially deficient?
No. And if I can just add, as well as the quality assurance process we had in place, once we had the service standards in place, we created a group of officers called Service Standard Support Officers that didn't have managerial involvement, and they were sent round to do programmed audits of stations to look at the various service standards. And the one that involved contingency planning, which 72Ds would sit under, would involve an annual audit at each and every station, looking at each and every watch in terms of their quality assurance. So we were putting these systems in place to make sure, as far as we reasonably could, that the processes were being adhered to.
Now, turning back to Mr. Eustace's email, he has a pungent turn of phrase, and he refers there to high-rise buildings that are dodgy. Upside-down maisonettes, dry riser outlets, only on alternate floors, etc., should already be on. Was it your understanding that those types of properties, or those properties giving rise to particular issues, had already been recorded on the ORD?
Well, I'd like to think so, but I don't think we could say, which is why I was so adamant that every high-rise should be inspected so we could be sure. Nothing could have given me the assurance that what Clive is saying here, that they should already be on. He says it exclamation mark, so I guess, yes, should already be on, but I wouldn't be satisfied they were, hence why I wanted everything inspected.
Yeah, the sentence seemed pregnant with doubt, looking at it.
Well, it could be read that way, or it could be, I guess, read as an air of frustration from Clive that they should all be on, so why are you doing this? But regardless of Clive's or anyone's view, I felt morally and professionally responsible to make sure that everything should be inspected, to make sure a decision made about whether it should or shouldn't be subject to future inspections.
Looking from the lay perspective, concentrating on, quotes, dodgy, close quotes, buildings, does that give rise to the danger that undue focus on those would ignore other high-risk presentations and other high-rise buildings, such as cladding, for example?
I mean, Clive has got a unique turn of phrase, that's for sure. But his bluntness was appreciated. I think what he's referring to in terms of upside-down masonettes is the challenges that you experience if you're not expecting them, in terms of the dangers that a firefighter going downstairs into a fire and the heat rising up the stairs can be immense.
Thank you. Now, can we, seems some time ago now that we started it, but can we go back to the Salamanca Place Incident Report? And that can be found at LFB 00106615/2. And this is the Action Plan Monitoring Report, and we see page 2, bottom row of the document, is the latest position in relation to Action 2, which is the action we've been discussing. What it says in the far right-hand column is this: 28th of September 2012, no database to be maintained. Ops News article to raise awareness for Cruz regarding the importance of carrying out and recording 72D visits in the correct format. And then below that, 20th of January 2012 and 4th of December 2012, as above detailed in Action 1. And then 14th of January 2013, it is agreed that there will not be a database maintained. Now, looking at that final entry, did you agree not to maintain a database?
I think this must be referring to the issue about a specific high-rise database, not that there won't be a database with high-rise on. And it's really important that we don't think that there wasn't a database with high-rise on, because there absolutely was, and that was the operational risk database.
Thank you. My question was, did you agree not to maintain a database?
I can't remember specifically whether I did or didn't agree, but looking back on it now, providing it was recorded on the ORD, I wouldn't have had an objection to there not being a specific high-rise database.
Can you remember who else was involved in making the agreement referred to here?
It would have been David Wyatt.
Would he have acted unilaterally or in consultation with you?
No, he wouldn't have acted unilaterally.
Can you remember now what reasons informed the agreement?
I can't remember for sure, but I am aware of the drive towards simplifying everything. So one database, one stop shop, and that I think would have been the motivation behind it.
Now, in that regard, can we turn to a witness statement of a former colleague of yours, Rita Dexter, and particularly a first witness statement? And in that document, she touched upon the difficulties of defining and identifying high-rise premises in London, which we've been discussing this morning. If we could go to LFB 000-32363/8. And if we can see at the very bottom of the page, it's paragraph 27. And she says this, and apologies for reading it out, it's probably helpful for people listening. I was present at the second meeting of the Lachnal House Working Group on the 28th of August 2013. Assistant Commissioner Steve Chirek, who reported to me, gave a presentation on the RRO, so the Regulatory Reform Order. His presentation included a recollection from information management colleagues, who also reported to me, go over the page, about the problems of defining and identifying high-rise premises, given the absence of adequate and appropriate data. At the time, this was seen by officers as an important issue, because uncertainty about the number, height, location and purpose of high-rise buildings was an impediment to fire safety inspection, familiarisation, 72D visits, and community fire safety work. It was an issue that we continue to work on over the following years. Now, from what you've been saying this morning, it appears that at least you share in broad terms Rita Dexter's concerns there about defining and identifying high-rise buildings.
Yes.
Would you agree that at the time, so we're talking here about 2012, there was no clear and definitive list of high-rise building locations for the reasons you've given?
We wasn't satisfied that we knew about every single high-rise, that's for sure.
Would you agree that the absence of clear data, at its most basic as to how many high-rise buildings there were in London, was an impediment to effective discharge of Section 72D?
It was a challenge that we were dealing with, yes.
Well, challenge is one of those words that's become tarnished with overuse. Impediment, I suggest, is the more accurate word to use. Would you accept that?
So without using the word impediment or challenge, I would describe it as the fact that we understood our duty and we did not know for sure of the amount of premises that existed within that definition and where they were. And we were making every effort to find them and therefore discharge our duty.
Now, she concludes in the final sentence of paragraph 27 that this was an issue that we continue to work on over the following years. Now, from 2012 onwards, what particular work streams that you're aware of were concerned with identifying and defining high-rise buildings?
So in terms of identifying high-rise buildings, there was work going on with the borough commanders. So just to put some context behind that for the panel, the borough commanders worked very closely within their boroughs with local authority, chief executives, borough commanders of the police, etc., tripartite arrangements. So there was a close working relationship, and it would be that the chief executive of the local authority would see the borough commander as the be-all and end-all when it comes to the fire brigade, and that was deliberately why that structure was set up. So that was a crucial link into housing providers, etc. So a lot through borough commanders. Then there was obviously right into chief executive level that Rita Dexter was doing a lot of in terms of reaching out through London councils and trying to find out from housing providers, working with housing providers, independent housing providers as well, trying to find out the various lists that existed of high-rise premises. But then there was also what is a high-rise, and that might seem a crazy thing to say, but it really was difficult in trying to determine what is a high-rise because people had different ideas. And we ended up, as you saw in the premises risk assessment, work on an 18-metre rule at 6 floors, but that was because when a dry riser no longer worked and we used a wet riser, so that's where water is already in the building on the roof and it comes down rather than being pumped up. And so we use that for our own definition, but you would find different definitions from different parts of London as to what was a high-rise. So we were wrestling with both of those issues in terms of trying to define a definitive list.
Did you, before you retired, looking at the last element of your answer there, were you able to agree and promulgate a unified definition of a high-rise building that applied across London?
We was for the purposes of our own staff and inspections, whether would every single housing provider agree with our definition, I can't say.
It just, in relation to an earlier answer, you said we'd find different definitions from different parts of London as to what was a high-rise. Are you referring there to different definitions being applied by the area commands within LFB, or are you talking there about different definitions applied by people such as housing providers?
Housing providers.
So not a confusion within the LFB?
No, within the LFB we adopted the wet riser stroke dry riser definition, and that was understood within LFB.
Yeah. Thank you. Can we now turn to Action 1, arising out of the Salamanca plays? And if we go to the SIA report, LFB 000 95042. And if we could look at action number 1, and the required action is this: raising awareness through operational news of the importance of station-based staff identifying complex and high-rise premises that should be inspected under the Fire and Rescue Services Act, Section 72D visits. The word complex had an asterisk next to it, and the asterisk says this: for the purpose of this SAI action, the term complex relates to premises that have an unusual design layout that would cause difficulties to crews when responding to incidents. Now, that action was allocated to the Assistant Commissioner OAS, which is Operational Assurance, I think?
Yes.
And at that time, it was Danny Cotton, is that right?
I believe so, yes.
And third officer, that would be you.
Yes.
Thank you. Now, if we can go back to the SAI Action Plan Monitoring Report from February 2013, which we looked at a few moments ago, LFB 00106615/1. And if we look at the fifth column on the first page, i.e. the most at the extreme right, now I'll let you just refresh your memory of that and let you read it briefly.
Yes.
Now, the thrust of the substance of that column is that awareness was raised through the publication of articles in Operational News issue 24 on March 13, and in the November 2012 Shout! Newsletter. Is that a fair summary of the actions taken?
Yes.
Thank you.
And associated training packages.
Yes. Now, in relation to Operational News 24, can we go to that? And that can be found at LFB 00050215. Sorry, it's an email. So it's LFB 00050215. Now, this is, rather than the article itself, is an email chain in relation to a draft of that particular edition. And if we can go to page 3 in this email chain, and it's really at the top, we see an email from Graham Ellis, timed at 9:19 on the 12th of January 2013, and he forwarded the latest draft to Danny Cotton and Gary Reason. Helpfully, Mr. Ellis has set up further in the chain the draft text of Operational News to which he's referring, and we see that at the bottom of page 1. So we see there, starts description of 72D visits. If we can go over the page, and it's really the third paragraph on page 2 I'd like to look at. It said this: fire station personnel will often be best placed to identify significant developments or changes to property which may have an impact on safe operations. Policy 800, Information Gathering Contingency Plans, explains the risk assessment process which should be used to establish whether a premises requires visiting, and describes the method of recording on the operational risk database. It is important that crews always refer to the risk assessment process when carrying out initial and revisits, as changes to the building or the risk matrix within Policy 800 can affect whether the premises is added to or removed from the ORD. Whenever a high-rise residential building is assessed to be entered on the ORD, a suitable line drawing of the layout should be included. It is also important that personnel plan for the possibility that any fixed installations are unavailable. Now, as we've referred to earlier, the reference to the risk matrix in Policy 800 is the formalised process by which a property is scored, and on the basis of that, visits determined and their regularity.
Yes.
And the property score then determines frequency of visits. Is that fair?
Yes.
And in the case of properties that are scored as being very low on the matrix, they don't need to be included on the ORD at all.
Below 149 and below, yes.
Yes. Now, if we can go, mindful of that context, if we can go to Danny Cotton's email, which is in the bottom half of page 2, so the one we're looking at the moment. And she says, "Hi folks, I still have some concern with the matrix in Policy 800 and what happens if the watch manager deems that the premises does not present a complex or unusual risk. I've discussed this a number of times with Dave Brown, as he and Dave Lindridge tried it out on Lachnal House and came up with different answers. I'm just concerned that we may end up with conflicting messages. Maybe you could have a quick chat at DMB." What does DMB stand for?
Directorate Management Board.
I know that the Commissioner wants the message to be reinforced in Ops News, but I would hate for us to confuse the opportunity to make sure that crews are increasing their operational knowledge. Now, Danny Cotton then says in a later email in the same thread, and if we go up to the middle of page 1, it's an email at 8:42, she says this, my main concern is that DB, presumably Dave Brown, DL, presumably Dave Lindridge, applied the same matrix to Lachnal House and came out with a, or should I say LH, which I'm assuming to be Lachnal House, and came out with a different response. And DB, you, said that he was confident that all watch managers would opt to do the work and make the buildings fit the more complex, challenging criteria and include drawings rather than take the easy option. And just to conclude the email chain, can we go to the top of page 1 and the email from Graham Ellis? Row of dots, he says this, and it would be fair to assume that the situation will not improve when there are far fewer crews to go out and do the work in the first place. I still think there needs to be a more systems-based approach where crews are provided with a list of premises that they should visit. The building information plates will also play a key role, as crews will be travelling further to attend incidents off their local patch. We are looking at Camden and Lambeth to trial the plates. I am keen that we don't get dumped with making it all work though. We have provided the idea and wise counsel, but I think RFS,
Regulatory Fire Safety.
and ORM,
Oh, I've never heard that that one before.
presumably operations response and mobilising,
Yeah,
I've
maybe,
assumed.
or operational risk management. I'm not sure, but
need to take ownership to move it forward. The matrix and policy owners really do need to get this sorted out though. There's a lot in that email chain, Mr. Brown. Can we take it step by step?
Sure.
First of all, did you and Dave Lindridge apply the risk matrix to Lachnal House?
I don't remember doing that. But it wouldn't have been an unreasonable thing to do.
Are we safe to assume that the matrix referred to is the risk matrix we've considered in Policy 800?
Yes.
Why did you and Mr. Lindridge apply the risk matrix to Lachnal House?
If we did do it, it would have been as a scoping exercise, as a test to see whether the likes of Lachnal House, had the premises risk assessment been in place at the time, would it or would it not have passed the test and been put onto the operational risk database? And the reason Dave Lindridge is because Dave Lindridge carried out the review of the Lachnal House action plan.
When was that work done? Can you remember?
What, the tester, if you like, for Lachnal House? Or?
Yeah.
Well, again, I want to caveat it, but I don't specifically remember doing it, but if it did happen, and I've no reason to assume that this is wrong.
I was about to say, there's no reason here to assume that Dan Cotton's wrong.
No.
So we can proceed on the assumption
Yeah.
you and Lindridge did do it.
Yeah. If it did happen, it would have been probably around the time that Dave Lindridge was doing his review, so that would have been late 2012, early 13.
Can you remember, did you and Dave Lindridge come up with different answers?
I don't recall that. I would say though that if you look at the premises risk assessment, it is a guide, so it isn't beyond reasonableness to think that you could come up with different answers. And I'll give you an example to demonstrate that. So one of the criteria is a building where 500 or more people reside in there. Now, if one person looks at it and think, well, actually, there's less than 500, another person thinks there's more, and there isn't a responsible person there to be able to clarify for sure, then straight away, whatever points are allocated to that decision might be on one person's risk estimate or another. So it would be foolish of me to try to say that actually every single premises risk assessment would come out identical. Well, what I would be very, very confident of saying, however, though, is even if there were these nuances, as I have explained, I am still absolutely satisfied that each risk assessment would land within the zone. So, for example, 500 to 750 points. One might get 550 and one might get 600, but they would both be in the right place.
So, on the basis of that answer, you didn't necessarily share the full extent of Danny Cotton's concerns about different answers being produced by different people applying the matrix?
No, I think what was behind Danny's concern, and a genuine concern, what was behind Danny's concern is that if there was different answers, that will be leading it to such a low score that it's above or below 150. That's what Danny's concern was. And I didn't share that concern because whilst I accept there is the potential for two different scores, that they would come the right side of 150.
Did you consider that any training measures were required to ensure sufficient consistency in application of the matrix so that the score did end up on the right side of 150, if I could put it that way?
Well, there were Ops News articles on MDTs and operational risk database, and there were associated training packages. And then we of course verified this because apart from the systems we've spoken about already, every training exercise that was carried out on high-rise or any building, for example, part of that training exercise would be to look at what was on the operational risk database. Every performance review of command and every performance review of operations would consider the initial information gathering, which was therefore on the operational risk database. Every fatal fire review we did would look at information gathering. So there was a whole range of what I would call reactive measures in place that we looked at as and when incidents arise, and we asked ourselves that question: was there sufficient information on that operational risk database?
Looking at Danny Cotton's email, her concern appears to be prompted by the Brown-Lindridge exercise. Were you aware at the time of any broader concerns that there was an inconsistency in application of the risk matrix so that properties weren't being accurately or appropriately scored?
No, I wasn't aware of any concern in that regard, and whilst I can understand people, their professionalism asking that question, I don't think it was a real concern because I truly didn't believe that this would become an issue, particularly at such a low level of scoring.
Thank you. Now, if we can just go back to it, so you've got it on the screen, so you remember what I'm talking about, is Graham Ellis's email. Top of page 1. There we go. Now he says there, he expressed a preference for a more systems-based approach where Cruz are provided with a list of premises that they should visit. Now, had Mr. Ellis been raising and explaining with you what he meant by, quotes, a more systems-based approach, close quotes?
And I can't recall Graham raising this. I can imagine what he means. I think he goes on to explain this in this email in terms of, or later email that you've shown me just now, in terms of just being given a list. Oh yeah, he does say.
Exactly, it's the extract I've just quoted to you, so provision of a list.
So I think that's what he's referring to.
So it's not much more of a substantive system beyond provision of a list then?
No, and for the record, I would completely disagree with the list because firstly, where is that list going to come from?
I was about to ask you, it's going to be the station manager, isn't it, presumably, or the watch manager?
Well, yeah, and then where are they going to get that information from? And this is all about ownership. This is about making crews own their station grounds and become part of the community and familiarise themselves with it. And there's a whole range of other reasons why we would want them to get out and about on their station's ground and do this. It's not just about information gathering, it's about being seen in the community, being part of the community, for people to come and ask advice. It's about being able to recognise people that are in trouble and need our help and refer them serious outstanding risk, home fire safety risk assessments, all designed to work in partnership with the local authority and the police to drive down fire and crime and to make, achieve our overall objective of making London a safer city. So it's far, far broader than just being out there. And if staff were just given a list to do that, then we miss a fantastic opportunity to do so much more good work.
Was that discussion a discussion that you had with Mr. Ellis at this time, so start of 2013, you've given a pungent analysis of the disadvantages of what he was suggesting. Was that a discussion that was had at the time?
I don't recall Graham Ellis ever actually raising this issue with me in those terms, but had he have done so, then I would have given the same answer I've just given then.
Can you remember Danny Cotton or anyone else raising it with you? Because obviously at this stage she was of AC, Operations Assurance, so it fell directly within her remit.
I do recall that Danny was concerned about the issue that we've just discussed, i.e. that things might not make themselves onto the operational risk database, and that was a genuine and professional concern. But in terms of just giving a list, as Graham suggests, I don't recall Danny ever mentioning that to me.
Thank you. So we're slightly early, but we've come to the end of the questions in relation to this topic, and the next topic will take longer than 5 minutes.
So it would be sensible to stop a little early at this point.
It would, sir.
Yes, very well. Well, we would normally stop about 1 o'clock, Mr. Brown, but the reasons that Mr. Kinnear's just explained, it's probably better to stop now. So we'll break now. We'll resume, please, at 2 o'clock. And again, please don't talk to anyone about your evidence while you're out of the room.
Okay, thank you very much.
Thank you very much. Would you go to the usher then, please? Thank you. 2 o'clock.
Thanks, sir.
Thank you.